Welcome everyone. This is attorney Candice Carr with Ouellette Carr and Spectrum Title Services. Thank you so much for taking a couple minutes to listen to this video. Today we're going to go over the FAR Seller's Disclosure Form. Again, this is the FAR, the Florida Association of Realtors, the Seller's Property Disclosure for residential properties. This has nothing to do with commercial property. Okay, so we're going to go through. I'm not going to read every single line of it. It's basically a question and answer format. I'm going to point out some of the more important sections that I feel both agents, sellers, and buyers should be aware of. All right, so the first one, the very top here in red bold print. This form must be filled out by the seller, and therefore it cannot be filled out electronically. I know a lot of people are using the digital signatures and such. However, this particular form does need to be printed out, and the seller does need to go through and actually complete it. Okay? All right, to start off with the notices. All of these notices are very important. A notice to licensee. The seller should fill out this form. You, as the agents, should not be completing this. Don't ask the sellers to just give you the answers and you fill it out. Give the form to the sellers and let them fill it out. Okay? Notice to seller. Florida law, and you can see the little notation here, number 1. If we scroll down to the bottom of the page, number 1 refers to the case Johnson versus Davis, which is essentially the landmark case on seller's disclosures when it comes to residential property. Okay? Florida law requires the seller of a home to disclose to the buyer all known facts that materially affect the value of the property being sold and that are not readily observable or known by the buyer. And when you ask what does material effect mean, we'll go over that in a couple more sentences. This disclosure form is designed to help you comply with the law. However, this disclosure form may not address every significant issue that is unique to the property. You should think about what you would want to know if you were buying the property today. So when we ask what does materially affect mean, I'll have the seller ask themselves, if I were buying this property, is this something that I would want to know about, and is this something that I would feel that would affect the value of the property and what I'm offering to pay for this. Okay? If the seller needs more space or wants to go into additional explanation about something, on the last page there is a whole section where they can do that. Okay, then a notice to the buyer. The following representations are made by the seller and not by any real estate licensee. So the buyer needs to understand that you as the agent are not making these representations and that you did not complete this form. This is what the information that the seller is providing. This disclosure is not a guarantee or warranty of any kind. It is not a substitute for inspections, warranties, or professional advice you may wish to obtain. It is not a substitute for your own personal judgment and common sense. Now, a lot of times when people get involved and their emotions get going in real estate transactions and buying and selling property, their common sense goes out the window. So they need to think about when they're walking through the property, if they see something that doesn't quite look right, and common sense may tell them they need to have this further inspected. The following information is based only upon seller's actual knowledge of the property's condition. Seller can disclose only what they actually know. Seller may not know about all material or significant items. For instance, if a buyer is purchasing an REO or a property that an investor is simply flipping, the seller may have never seen the property. They've probably never been to the property, and on most, probably all of REOs, there's not going to be a seller's disclosure because the seller's just going to don't know about everything. These banks, they don't know anything about the condition of these properties. They're being sold as is. It's up to the buyer to do their inspections. You should have an independent professional home inspection to verify the condition of the property and determine the cost of repairs, if any. This disclosure is not a contract and it's not intended to be part of any contract for sale and purchase. So this is not an addendum. This is not a rider to the contract. This is simply a disclosure form. Okay, seller makes the following disclosure regarding the property described as, fill in the address. Property is owner occupied, tenant occupied, unoccupied. If unoccupied, when did the seller last occupy the property? If they didn't, then you just put NA. Alright, now like I said, the format is question and answer. So all of these sections here are going to be asking questions. The seller is going to check yes, no, or don't know. And at the end of each section, there'll be a couple lines for a further explanation. If the seller needs more room, if they have a lot more to explain, again, there will be an additional page there for them to do that. Section 1, Structure, Systems, and Appliances. Are structures including roofs, ceiling, walls, etc. structurally sound, free of any leaks? This is especially important when it comes to roofs. A buyer would want to know if there are any potential roofing issues. Is there a seawall? If there is it structurally sound? That's only not going to apply to all properties, obviously. Are all major appliances in good working order? Heating, cooling, electrical, sprinkler systems. Are any appliances leased? A lot of times properties have natural gas. Some of those tanks are often leased. Section 2, termites, very important in Florida. Are there termites or other wood-destroying organisms on the property, or is there any damage? Yes, no, or don't know. The next one, has the property been treated for termites or other wood-destroying organisms? So if yes, then you're going to provide an explanation. Yes, was treated for termites 6 months ago. Everything retested, came back clear, whatever the situation is. But even if there are currently no termites or other wood-destroying organisms, if it had been treated in the past, that's something that needs to be disclosed. Water intrusion, drainage, flooding. Has there been any water intrusion affected the property? Are there any drainage or flooding problems? Is it in a flood zone? It asks here, section F, if the seller has an elevation certificate. If the buyer is obtaining a loan, we as the title company will order a new survey and an elevation certificate regardless. So that's not something that the seller has to have. We'll know that information. Okay, next page, section 4, plumbing. What is the source for drinking water? Public, private well. In West Broward and the ranches and a lot of Davie, a lot of those houses will be on well water. Have you ever had a problem with the quality? Is there a water treatment system? Is there a sewer or septic? A lot of these are very easily answered. The seller shouldn't have too many problems answering yes or no to most of these questions. Section F, have there been any plumbing leaks since you've owned the property? Are there any gray pipes? The other common term for these pipes are gray pipes. There are some developments where all of the houses do have gray pipes. This is something that needs to be disclosed. Pools, hot tubs, or spas. Florida law requires pools, hot tubs, and spas that received a certificate of completion on or after October 1st, 2000 to have at least one safety feature as set forth in the statute. And so section A here, you're going to check which safety feature the pool or hot tub, whatever it is, which safety feature they have. Has an in-ground pool been demolished or filled? Sinkholes. I'm not going to go over all of these. It doesn't come up that often, but if it has been an issue, if there have been any insurance claims, there have been any damages for sinkholes, is the seller aware of any settling or soil movement? That all needs to be answered. Section 7, deeds, association restrictions, access roads. Now, this is not a substitute for any applicable condo or HOA rider or addendum that needs to be attached to the contract. This is just the disclosure form, so those riders need to be filled out as well if they apply. Because again, this disclosure is not part of the contract. Are there any deeds or homeowners restrictions? Are there any proposed changes? Any resale or leasing restrictions? The seller may offhand not know this information. They could easily find it out by contacting the association so they can go ahead and properly answer these questions. Are there any driveways or fences or something that's shared with adjoining landowners? Are there any easements, any encroachments? For instance, does a neighbor have the right to access their property through this property? Those would be the types of things that would need to be explained here. Okay, Section 8, environmental. Was the property built before 1978? A lot of you are already familiar with the lead-based paint disclosure. That needs to be done if it was built before 78. Is the seller aware of anything that's considered environmental hazard? Paint, asbestos, mold. If a buyer has an inspection done, or if on their own inspection walkthrough that they do, they see or smell what could potentially be mold, they should go ahead and have a separate mold inspection done. A seller that's been living there for a long time may not know that the bathroom smells like mold, and that's not something they disclose. So this is where common sense comes into play, and a buyer should have an additional inspection done if they think there may be an issue. Okay, any mangroves, any environmentally sensitive areas located on the property? Or there are certain trees that cannot be removed for environmental reasons, etc. Governmental, any zoning violations, any zoning restrictions, any land use conflicts. Does the buyer plan on doing an addition or making some change to the property that may be restricted by the use of the land? Okay. G is pretty important. Have any improvements or additions to the property been made, whether by you or others, and they've been done in violation of building codes or without necessary permits? So has there been renovations, new kitchen, new bathroom, something that would have required permits, and the seller didn't obtain them, or they know that a previous owner didn't obtain permits? This is something that's come across my desk quite a few times, where a buyer subsequently, after closing, learns that the kitchen was done, all the electrical was changed and replaced, and it wasn't done to code. And they then have to have it all redone properly and brought up to code. If this happens, a seller, or buyer rather, could then look to the seller for reimbursement of the money they have to pay to do that, if the seller was aware that these things were done, or if they in fact did them themselves without obtaining necessary permits. H, are there any active permits that have not been closed by final inspection? Are there any violations, non-compliance, unrecorded liens? Most code violations, county and city liens, those will come up on our title search. There's really no reason for a seller not to be aware of them. These things get mailed to the mailing address that the appraiser has. They get mailed to the property, so there's plenty of notice that's given for code violations. Okay, 10, you're going to check this, or the seller is going to check this if they're using that additional page for additional comments, informations, etc. Alright, now above the signature line, seller represents as information provided on this form and any attachments is accurate and complete to the best of seller's knowledge on the date signed by seller. Seller authorizes listing broker to provide this disclosure statement to real estate licensees and prospective buyers of the property. Seller understands and agrees that seller will promptly notify buyer in writing if any information on this disclosure becomes inaccurate or incorrect. So the seller does have a duty to update this information if something changes. The seller is going to sign, make sure they date, it's very important. Buyer will then sign and date that they've read, understand, and received a copy of the disclosure. And there's also initials on each page. And then the last page here is where seller can provide any additional information they feel is necessary, and this one as well will be signed and dated. Okay, so that's the FAR seller's disclosure form for residential properties. Thank you so much for listening. If you're not already using us for your closings, we really would like for you to give us a try. We have 2 attorneys, myself and Adam Ouellette. We're always available to answer questions, to provide guidance to you. So there's no reason not to give us a try and see how we work together. Take care.